No, it picks up from the TV and from the back,
Oh,
so
okay,
you should be
okay,
good.
okay.
And we verified that people online are able to hear us
Oh,
fine,
wonderful.
so everything should be good.
Great.
So thank you so much for coming. This is the second class in our series that we're partnering with Pierce County Aging and Disability on advanced aging and elder care. Although we say that, and it really isn't just advanced aging or elder care, and it's not just for caring for aging parents, because really this information applies to us, right? As we prepare for ourselves in terms of legal documents that we might need to have. And we're going to talk a little bit about more of that later. I've got some questions for Matt. But also, we might be helping out a sister or a neighbor or a customer or something like that. So this is just great, valuable information that I think every human in our state for sure, in our country really needs to know, just as we prepare for the future. So without further ado, I want to welcome Matt Santelli. He's an education and outreach specialist with Pierce County Aging and Disability, and I've got the honor to intersect in a number of different ways with Matt. He is an absolute wealth of information and really brings some good information that we need to be successful. So thank you, Matt, for joining us, and I'm going to turn it over to you.
Great, thanks. Thanks for tuning in. Thanks for being here in person. Yeah, I work at the County Aging and Disability Resource Center. For those of you in the room, I left some upcoming event information and things. And this is a talk I put together from my own experience in working with clientele, family members, clients themselves, spouses, on what you have to look at in terms of planning for future decision making. And by future, it could be tomorrow. People think that, oh, I have to plan for this for much later in my life. Well, at any given time, we've all had friends or family members who have been stricken ill, could even be in a situation where they're so ill they're unconscious. Who's going to make decisions for them to keep them alive? Who's going to maintain their financial situation so they don't fall into some sort of great financial distress? So those will be some of the conversational things we'll talk about. We do have a list of elder law attorneys at our office. If you call us, and our information, my phone number, I think, and all the information is in the very end of the presentation, the back slide on resources. But you can always call our office and get some guidance on that. I have some other resources on there as well. Because when it gets into the nitty gritty, you want to make sure you're talking to an elder law attorney who knows the rules in the state of Washington that govern things like power of attorneys, living wills, last will and testament, guardianship. And depending upon the whims of the legislature, those rules can change. So you need someone that's on top of that thing day to day, week to week, and month to month as well. Next slide. Oh, sorry. Disclaimer, like I said, I'm not an attorney. We're not going to have the ability to exhaustively look at every legal document that might come up in situations where you're doing long-term care planning. We always recommend that in seniors, their spouses and partners, their family caregivers needing support should review legal resources, including consultation with an elder law attorney during the planning process. And state to state, what those elder law attorneys might tell you can be different because most of these legal situations are governed by state rules. Federal rules are not so much as meaningful when it comes to on the ground decision making as to what a healthcare situation might look like or a financial situation might look like state to state. So let me give you one example of that. Social Security, for example, does not recognize things like powers of attorney. So if you were to call Social Security or go to the office and say, I'm my mom's power of attorney, can you put that in the file? They won't recognize that because it's a state by state situation, not a federal situation. The only thing Social Security would recognize if you were that person's assigned protected payee. So that's why I'm saying state to state, it can vary. And within the state, year to year, it can vary as well. So you want to get attached to a good elder law attorney to help you in the planning. So what topics we'll go through very loosely, we'll talk about why decision-making and planning for it's important. What are the most important legal documents on decision-making? Typically, those are going to include things like financial and healthcare durable power of attorney documents. Talk a little bit about protected payee. We'll talk more about that. Advanced directives for healthcare, or a living will, also known, is typically the script that your decision maker would be following, or if you're a decision maker for someone else, that's the script you would be following. We'll talk a little bit about guardianship filings, POLST forms, A little bit on hospice and palliative care. We have a series, a session later in the series about hospice and palliative care, but we'll talk about that a little bit. Last will and testament and some additional information, resources, and legal assistance. So after every couple of slides, I'll just stop and take any questions you might have or raise your hand. I think we have a small group today, so no problem at all in just raising your hand if you have a question, if you're viewing online or here in the classroom. So why is planning for decision-making important for everyone? I think most of us realize the population is getting older. The number of older adults who need care right now is rapidly growing. One problem we're running into statewide, nationwide, is a lack of trained caregivers to work in care facilities and in home care agencies as well. It's very difficult here in the state of Washington and specifically in Pierce County to find adequate staffing for agencies to take care of older adults and disabled younger adults that are willing to do the work over a long period of time. We have a lot of agencies. Most of them are struggling with staffing, having people available. And there are certain parts of Pierce County, like Anderson Island, we don't have really any service out there because it's so dependent on the ferry schedule. So we can't get agencies to get people out there that are willing to wait in the line at the ferry, go over there, have to get back in time. So we're trying to build organic kind of supports out there in Anderson Island, maybe someone who lives there that's willing to be a caregiver and work for an agency. But building up those situations is really difficult. Fastest growing group of people in the United States are those 80 years or older. That leaves fewer young family members to provide adequate care and support for them. It's a much more mobile population now than it used to be, especially with remote work. We know a lot of people from the COVID years that decided remote work was for them, and companies were able to support them in that. So living close to where you work has changed. So people live farther away from family members as well. Dual income households are increasingly more common, less time for caregiving. We know that people are having fewer children, they're getting married later. So there's more and more situations, not only where there's not enough people in the family to take care of the elders in the family, but sometimes you're in that sandwich generation where you're trying to take care of an older adult in the family, but you're also still having kids at home to take care of as well. All of these factors play into the situation that fewer people are available to act as decision makers for family members and loved ones. If patients don't have a family member to make decisions, they need to privately pay for that care management, apply for government-sponsored care at home, or seek placement in a care facilities. And professional care facilities cannot act as decision makers, but are often the only option for family members seeking consistent quality care. So it's not unusual that people living alone will come up to me after one of these talks. It happened when we were up in Tehila, whatever it's pronounced. And a gentleman came up to me and said, you know, I never got married. I don't have any kids. I have one brother. I'm not close to my nieces and nephews. You know, who's going to be my decision maker? So these are the things you kind of have to start discussing with the family members you do have, or looking into some professional services that are going to do that work for you. And it can be really challenging because we do have a lot of seniors that live alone, have lost spouses, or estranged from their kids, or never had children, or the children moved away. So it makes it very difficult for them to find someone to be that decision maker. One of the issues we had with hospital overcrowding the last few years is that a lot of people were sick from COVID, were in the hospital, and didn't have an assigned decision maker, and there was no one we could find to be decision makers for them. So they languish in hospitals sometimes for months at a time until the guardianship process can make something happen. It's a very long, difficult process. Even with that process, if this person is bereft of funds or assets, very difficult to find a professional guardianship service that's willing to work with them. So this is a real issue that's affecting a lot of our healthcare availability as well. Next. More on why planning for decision-making is important. Illness or injury causing loss of work or lifelong disability can happen at any age. And then typically it's family members that often have to take over very quickly and be the caregivers and the decision makers. Actually, I remember working with a gentleman years ago. He was a firefighter, actually, I think where was that? It wasn't in this part of the county. I think it was closer over into Roy. And he was actually unloading some material from his truck one day on a Friday, lost his balance, fell out of the back of the truck, and total paralysis. I mean, just like that. And his wife was just like going from a very functional marriage situation, financially and otherwise, to all of a sudden, this gentleman can't work anymore, he's disabled, he can't take care of himself. So it can happen that quickly, unfortunately, and we've all had experiences like that in our friends and family members. Overall, 30 to 70% of husband, wife, and partner caregiver situations in that 60 and over age group, the caregiver dies before the person they're providing care to dies. And those situations can be quite dire. I'm sure the folks here that work in the field in the East Pierce Fire and Rescue see those situations. And that's why planning ahead is essential, not only for the caregiver, but for the care receiver as well, and for everyone else in the family as well. And we'll talk a little bit about the limits of what those decision-making documents allow you to do. And the limits are mostly because the person that you're trying to make decisions for may not be cooperative, like the situation you're describing, unfortunately. So sometimes, even if you can get to the point of having the documents in place, you still have to have that person trust you enough to cooperate with whatever care plan you're trying to put together with them. Any questions so far? Anything we talked about? Pretty straightforward. These documents, again, we'll talk about are specific to the state of Washington. Each state administers them a little bit differently. So we always recommend that you have the documents specific to the state in which you're residing. If people are snowbirds, we recommend that they have a set of documents for the other state they might be residing in. And remember that if you do move to that other state, you need to update these state documents to follow the other state legal guidelines. I've gotten different answers from different elder law attorneys that will say, well, yeah, they'll honor the documents from this state if you're there. I don't really buy that. I think depending upon where you are, and if you're going to be somewhere a long period of time and then in another state, you really should have those state-specific documents available, notarized or witnessed by somebody in that state. Similarly, if you have friends or family members who come here, they need to update their documents to follow the state of Washington legal guidelines. In years past, it was a little bit broader and a little more looser on that, but I think it's really tightened up. And the tightening's because of concerns about identity theft and things like that. I think folks in the state of Washington are less likely to honor a document if it has a notary stamp from Florida or something like that. I think those are just kind of safety concerns because they want to make sure the person that they're dealing with, especially in a financial situation, is truly the one that that person has assigned to be the decision maker. It's much more difficult to verify that, quote unquote, if a person's got those documents from another state. Next. So we'll dive right into talking about the different documents that are really important for you to think about having for yourself, to assign children to be your decision maker, or to talk about your aging parents and having them assign you as the decision maker. The first being a durable power of attorney document. This is a document that designates another person or persons to be your agent to make decisions for you when you're no longer able to do so. So in my situation with my parents, I think it was around 2012, my mom had an emergency appendectomy, almost died, but she did recover. And that's when we started to put together these legal documents. We actually did a whole family trust because they had a lot of real estate holdings. That's not necessarily the thing you need to do in every family to have a trust set up, but you at least want to have the decision-making forms. Because in a situation in the state of Washington, if you don't have the forms, husband and wife, it defaults to the other spouse. My dad has never really been a caretaker, decision maker for my mom. He's always taken good care of her, but he's native born in Italy. Even late in his life, his English wasn't all that great. So he didn't quite understand what was going on with her and why it was so serious. So that's when we realized, okay, someone, adult child in the family has to be decision makers for them to talk to doctors and do things like that. So the durable power of attorney documents typically are two parallel lines that they go on: financial power of attorney and then healthcare decision maker power of attorney. Should be completed consulting with adult children or other trusted adults. Should be written to be effective immediately, avoiding effective at incapacity clauses as possible. This is my view on it. Having worked with my parents, on this issue with regards to an effective and incapacity clause. So with my parents, my mom already having had that emergency appendectomy, completely a surprise because she understood and her doctor had even thought she didn't even have an appendix. Now, maybe appendix can grow back, I don't know, but it was a shock to find out that she'd been dosed with this emergency appendectomy situation because her whole body was toxic and they had to cleanse her organs and do all these things, and we didn't even know she had an appendix. So that's why that sudden shock of that happening, we realized as they were into their late 80s that at any moment one of them could be seriously ill or injured. And then trying to show that they're incapacitated to make the documents active would have been well nigh impossible. So basically what we're talking about here is that you can set up a power of attorney. Like if I wanted to set up a power of attorney for my son, I would tell him, okay, you're going to be my power of attorney for healthcare and decision-making. This document is effective now that you could have that power rather than later only if some doctor verifies that I'm incapacitated. And this is where that trust comes into play because the documents are typically held by that child you trust, like my son would hold the documents, I would hold the documents, but we just wouldn't put them into action. It's very difficult to put the documents into action trying to show the person suffering from an incapacity of some kind. But the documents typically do read, is this document for decision-making active now, or does it only become active later when I'm declared incapacitated? In my experience with my mom and dad both, there's no situation where their primary care doctor would have ever said they were incapacitated. He just would not do it. Even like with the driving thing I discussed with you, he would never say, I think they shouldn't be driving. He would say, now you as a family can make a report to the state patrol from what you've seen them driving, but I have no view of whether they should be driving. I have no view of whether your mom should still be making financial decisions. I have no view of whether you should be their healthcare decision maker. And rightfully so. I think most doctors, even if they have a lifetime relationship with the person, really only see them a few minutes a year, right? And so it's a big lift for them to take that chance of saying, you, my patient, are no longer capable of making your decisions. Most of them will really reluctantly even have that discussion. So this is why it's always a challenge. Family members sometimes think, well, the doctor is going to make this decision for me. It's really not a diagnostic decision. It's really a decision that you as family members make in talking with your parents, or you as a parent in talking with your adult children about how this whole process needs to go forward. So that's why I'm really leery of saying you have an effective and incapacity clause. I think in the state of Washington, an incapacity clause has to be enforced by two different doctors saying that you're incapacitated. So good luck with that. It's going to be impossible finding one, let alone two, who's going to make that declaration. So with my parents, after my mom's appendectomy in 2012, we had all the documents in place, had the will in place, the living will, the power of attorney forms. We didn't actually use them again. We just put them in the box probably until 2019, when my mom really got the decline with her vascular dimension. And my dad even a year later than that, because he was doing fine until he fell and broke his ribs in the yard and went into a care facility. So there was really no need for those documents because my mom went back to writing checks, paying the bills, meeting with the doctor, and everything was fine. So there's an example of the documents were in place and ready to go years before they were actually needed. So any questions on that? Yeah, comment?
Well, I'd like to kind of chime in from the 911 perspective, a couple of different scenarios that we've faced for our firefighters that are going to be viewing this, this video after the fact. So there, early on when I became a community resource paramedic, we were working with a couple down in Sumner that were older. She was really physically incapacitated and he was likely mentally incapacitated. And together they were just really not making decisions that were allowing them to thrive. She was falling a lot, so we were starting to get a lot of 911 calls for falls. And they had a daughter that was involved as best as she could, and the daughter was designated as power of attorney, but there was an incapacity clause on it, and it did require two doctors to declare that he was incapacitated. And we attempted, she attempted, and there was no way that they were going to find two physicians that were going to declare
There you go.
him incapacitated. And we basically, unfortunately, had to wait until, one of them took a fall that was so bad that they ended up hospitalized.
Yeah.
And then one of them died. And it was a really unfortunate situation. But we may face those situations on 911 calls where we may have somebody, saying to us, they're a power of attorney over their parent, and maybe wanting to reverse that parent's decisions,
Yeah.
right? The parent may be saying, I don't want to go to the hospital. And you have an adult child that's saying, I'm power of attorney. I want them to go to the hospital. Ask to look at the power of attorney. If
Yeah.
you don't feel like that, if you want to honor that parent's wishes, if that power of attorney says it's only effective upon incapacity, then you have the right to be able to say to that power of attorney, to the adult child, I'm sorry, this power of attorney is not effective at this point.
Yeah.
We're going to honor the wishes of your parents. So just something to keep in mind.
Absolutely, absolutely. And if anything in the state of Washington, the last few years, I would say that I want to say weakened, but they've really modified the significance of the role of that power of attorney. The state legislature seems to always kind of be on the fence of how much power they want to provide to those people that are assigned powers of attorney. And the laws can be very specific in saying, yes, like you're saying, if the person in question says no, the power of attorney saying yes, I think they default back to the person in question, of course, because that's the person, right? So again, these are things where I really want you to talk with elder law attorneys about what specific powers a power of attorney has and how are they quote unquote enforceable. One thing I will say is that people will call us at the county and say, well, I'm the power of attorney and my brother keeps interfering. There's no power of attorney police force out there that you can call to make that right. It's within the family. It's family discussions. And that's when I think on the caring for the caregiver, the long-term care planning discussion that we had in the previous sessions, it's all about communication within that family. Because if you have an active saboteur in the family, that super saboteur is the one that the parent is going to listen to. They're not going to listen to the person that's putting them on the right, healthy, and well path. They're going to default to listening to the person who tells them what they want to hear. So this is again why those discussions are so important, to make sure everyone in the family is recognizing, or at least be willing to keep their mouths shut when the power of attorney person in the family is trying to do the best they can for the parent's health and wellness. Anything more you want to say?
I do have another question though.
Yes.
So we have a couple of firefighters that both have had unique situations, and I want to see if you have any thoughts on
Yeah,
this.
try.
So both of them had children that were over the age of 18. One, her son was in his early 20s. He had a child with another woman. He went missing. And the family knew, they suspected right away that there was foul play. And
Right.
they were told by the police that they couldn't even file a missing persons report unless she had power of attorney. She being the firefighter, this is her son that's missing. Unless she had power of attorney, she couldn't file a missing persons claim on him for 3 days. So the kind of implicit recommendation there is that maybe parents should have power of attorney for their children, even adult children. The second scenario, one of our firefighters, her daughter, who was 19, went down to Arizona and she ended up roofied. And she was taken to the hospital, and our firefighter, flew down to try and, be there for her. And the hospital initially weren't going to give her any information on her daughter because her daughter was technically an adult and she didn't have power of attorney. So just wanted to get your thoughts on that concept of, parents having power of attorney for their adult children so that they're still able to make some meaningful decisions if that child, that adult child becomes disabled or, has a healthcare issue or is missing or something like that.
No, it's a great question and great scenarios there. That surprises me, that 3-day rule on the missing person. I don't know enough about that. But let me just say that among all the different caregiver programs we have, it's not unusual where a parent is caregiver to an adult child. Whether it's a lifelong illness or injury, or whether it's something that happened later in life, stricken by a disabling illness or a motor vehicle accident, a shooting, whatever the case might be. So yes, it's not unusual among the many different caregiver programs we have that many of our caregivers are a parent taking care of an adult child. So that being said, yes, it would have been nice early on in those situations, I'm sure, that that parent had already been assigned decision maker for that adult child. Might be a bit of a heavy lift in a lot of families where an adult child is trying to become more independent of their parents, and that discussion takes place. But it's certainly not something that would be unheard of, that might be necessary sometimes. So that's, again, those are where those family decisions come in. I certainly would say that, yes. With our son, I know we did do a power of attorney for him because he liked to bike a lot and travel a lot and go camping a lot and things like that. So we thought it would be important that if he could get injured or ill and he's all of a sudden in a different state and ill, or in a different part of our state, that we could be designated as the decision maker. We did something similar to that when he did an overseas trip. We had like an international, travel insurance policy that had like a decision-making provision in it in case we needed it. So yeah, I would certainly recommend, if you're willing to have that discussion, someone's got to start the discussion. And so this is why, again, those family discussions early on are so important, because you have to have the document all set up, notarized, witnessed, all that, and to make the document valid. But you have to do that early rather than later, because once a person's ill under the state guidelines and they're losing their ability to understand things, or they're unconscious, they can't be obviously signing a document in those situations. Now it's going to kind of depend on the notary, because it's really the notary validating that the person in front of them understands what they're signing and what's being notarized. There's some mobile notaries that would probably stamp anything that comes in front of them as long as you pay them the fee. But there's others that are very conscientious. They're going to say, no, I don't believe this person understands the nature of this document they're signing, that I'm going to stamp for them. So any of these documents and talking about them should happen early, whether it's a parent talking to an adult child talking to a parent, when everybody's aware of what's happening, who they are, what the document does, how it can be administered, all that early on in the process should really happen. So,
Thanks, Nell.
yeah. Okay, so we talked a little bit about Social Security, and this is where state versus federal kind of plays into this whole thing. Social Security does not recognize power of attorney documents for sharing confidential recipient information. You have to be assigned as the protective payee to act on their behalf, obtain information, and make changes. You can go on the ssa.gov website to learn about being assigned as a protective payee. It's basically you as a family member that then would administer the Social Security funds for that person. I think typically they ask you to be listed on the bank account as a protective payee for that person. What we did with my parents, in addition to the power of attorney forms and the family trust, we added certain adult children to the bank accounts. So we went into the bank with them. They agreed that we would be fully active members on those bank accounts. And then it really wasn't that meaningful, because every month the Social Security payment would just go into the account. We didn't really need to talk to Social Security about anything. One thing I will say is that as a person loses capabilities, like my mom with her dementia, trying to have them talk to anybody on the phone about financial or healthcare decision-making is really, really frustrating, and it will probably fail, because I did my best to kind of coach my mom and even put a script in front of her. Even if she was able to read from the script, I remember once someone on Social Security realized what was going on and said, I'm sorry, this sounds like a fraudulent call. It sounds like your mother's reading from a script, which she was. So again, there's workarounds here than becoming the protective payee. You don't really need to do that. You just have to make sure, though, that you have awareness of the Social Security correspondence that's coming in terms of the mail, and understand which bank account those payments are going into. You can go on ssa.gov, do an account on there called My Social Security, and have access to that as a family member. That's another thing you can do. So you can print out end of the year statements. You can print out award letters. Sometimes you'll need those things for some sort of financial decision you're making for them. We refinanced my parents' house at one point after they were incapacitated. And so I was able to print award letters and end of the year statements from socialsecurity.gov as proof of what some of their income was. So there's one example of that. Any questions? Okay, next. Okay, so we talked about powers of attorney for financial and healthcare. In addition to the healthcare power of attorney, you want to consider what's known as a living will, or also known as an advance directive. An advance directive document provides instructions for you as the power of attorney to follow for end-of-life wishes, such as medical treatments you do or do not wish to have if they're terminally ill or permanently unconscious and unable to make decisions. Instructions for when you are dying might include whether you want only hospice care to keep you comfortable and free from pain, whether you want artificial hydration, whether you want artificial nutrition or other means of life support. So sometimes this might be a process where, like with my mom, it was a long, steady decline. With my dad, it was a little more abrupt after he fell. But we all know folks who do fall, have a head injury or something, and then all of a sudden there's this dramatic situation going on. With my uncle, for example, he went in for knee surgery, which he had been putting off for years. The knee surgery went well, but they said his lab work looked a little odd, and they'd call us after we went back home. So no sooner had I put him in the car, took him back home, than the doctor called and said, you need to get him back here immediately. He's in full kidney failure. Looks like he has leukemia. So literally we had to just turn around from the house, go back. He was admitted, he was unconscious. We had the power of attorney forms in place, the living will, all of that because of the knee surgery. We had no idea that he was terminally ill with leukemia. So this is how suddenly it can change. But fortunately, we had all those documents in place. We had the living will in place and everything. So subsequent to all that, a few months down the road, his cancer was in full remission and we thought everything was fine. Everything was calm for a few months, went back for a checkup with the oncologist, and boom, everything was crazy off the charts. Leukemia was killing him again. And so we talked about different options and things. And he said, Matthew, I just want to go home right now, go to sleep. So went home. I checked on him the next day. He didn't answer the door, went inside. He was unconscious in bed. Got him down to the ER, and the ER doctor said, well, he's got an intestinal blockage. We could do surgery on it to clear it, but you do know he's terminally ill, right? I said, yeah, I do know he's terminally ill. And he said, what would he want to have happen here? And I said, well, the living will was pretty clear. He didn't want any extraordinary interventions to keep him alive. We just want to keep him comfortable. And the doctor said, well, I was talking to the Franciscan Hospice House for another patient a little while ago. They decided they wanted to take her home rather than sending her there, but I know they have availability. So we got him to the Franciscan Hospice House. He was there, I think, 12 hours and he died, but they had him completely comfortable on pain medication. So that's just an example of, I already had the living will. There was no question, no, we're not going to perform surgery on him. Again, it was the doctor asking me, what do you want to do as his decision maker? It wasn't the doctor telling me we're going to do this surgery. It was the doctor looking to guidance from me. And fortunately, we had the power of attorney forms in the living will, so it was very easy to follow. It's nice to have that script in those situations because my uncle didn't have any wife, he didn't have any children. I was his godson, so there was no one questioning that because everyone in the family already knew he was ill. But sometimes you will have siblings that question things. And they'll second guess you as the power of attorney and say, no, mom told me something different. So having the living will witnessed, signed, notarized with your parent's signature on that can avoid a lot of those arguments. Now, there still might be arguments, but at least you'll know, no, my mom and dad went through this document with me, and this is what they told me, and this is the proof I have in front of me, okay? There's also a document known as 5 Wishes that expands on the basic advanced directive instructions, includes other aspects of end-of-life experience. So the 5 Wishes has things like, what kind of books do I want to have read to me when I'm unconscious? What kind of music do I want playing? Or is there a certain scents that I want in the room, like candles or some sort of air fresheners, things like that? Do I want a foot massage? Things like that. So you can write like a whole story of what your end of life atmosphere might be using the 5 Wishes document. And you can find that there at 5wishes.org. Any questions on advanced directives, living wills, all of that? And again, this is stuff you want to have done early. My uncle's last name was Spina. My last name, of course, is Santelli. With the documents in place, there was no second guessing from the doctors at all. Once I had the documents in place and said, here they are, they would call me on a Saturday, say, you know, your uncle's still unconscious. We need to do a blood transfusion. We need to start this infusion of this other medication to support his kidneys. There was never any question with the documents in place that I was the decision maker and I was the person they were supposed to be calling. Okay. So the documents will be honored if you have them, and the medical facilities seek out those documents because they don't want to be in a situation where they're trying to determine what's best for the patient, especially in like an end of life situation, because what's best is typically what that person talked to a family member about. It's difficult from them from a medical lens to determine what's best. They can keep people alive. They could have kept my uncle alive longer, but that's not what he had wanted. So he died within about 12 hours of that ER visit. So, okay, guardianship filings and petitions. This is a jump beyond power of attorney. So with the power of attorney form, you're sitting down, like I would be sitting down with my son saying, okay, I'm assigning you this power of attorney, healthcare and financial. Here's where the bank accounts are. Here's who my doctors are. Sign it, file it away. You have it though if you need it. A guardianship is basically where I would say, I don't want you to be my decision maker, son. I'm doing fine. And yet I'm in some state of decline. Declining financially, declining functionally, declining by health. And I'm not willing to say that I need help. So there's a process called guardianship that handles those situations. So a guardian is a person appointed by the court to help you make decisions about your health, safety, and self-care. Generally, when we've had successful guardianships filed, it's been outside of the adult protective services world, and we'll talk about that. This is generally where a person has a substantial estate of some kind, at least a few $100,000, and they're not taking care of themselves. And then typically it's a family member working with an attorney to file in court to have a guardianship assigned for this person. So for example, I had a lady that was living in a mobile home down in Puyallup off of River Road there. Unbeknownst to me, she had like $500,000 in the bank because she lived like a pauper, and she was living like a pauper to the detriment of her health. She didn't have her power on. She didn't have her water on. She didn't want to pay any of her bills, had a meager amount of groceries that she would get. Everyone in the mobile home park thought that she was impoverished, that she wasn't. And so we couldn't get her on any assistance programs because she did have all this money in the bank. She should have been spending her money for her care. She was an immigrant from a culture that says you never spend your money on your care, right? You save every penny. So she was languishing in this mobile home park for years with $500,000 in the bank. Finally, we were able to get in touch with her son east of the mountains here in Washington. He said, yeah, she told me to go away a long time ago. But he recognized the situation. He wanted to help her. He went to an elder law attorney, had a guardianship filed for her. He didn't want to be the guardian, so he had assigned a professional service agency to be guardian for her, to pay for getting some care in the home, to putting the lights on, the water on, getting her new clothes, all of the things she needed. So in my experience here in the state of Washington, the guardianship process for someone who has a substantial estate can be done efficiently, but it's still adversarial. It was still that son providing a court order to mom saying, you need to appear to defend yourself because my view is that you're incapacitated. So it is adversarial. It's son against mom. She was not happy about it, but she had no means to respond to it either. She didn't know how to get to court. She didn't know how to get an attorney to represent her. And so the filing just went through. Now, sometimes you'll get a person that's saying, no, everything's fine with me. I hate my son. I'm going to battle this out with him. And then you have those battles that go on, an adversarial battle where you're in court, they're in court, and you're pleading in front of the judge to make a decision. You don't need a guardianship if you have a power of attorney document in place. So this is usually a situation where there's something declining in that individual's life that's threatening their health and well-being. You've tried to get a power of attorney set up so you can get them to the doctor and communicate with doctors and get their bank account set up and spend their money for their needs. And they're saying, no, 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 I don't want to do it. And that's where you jump beyond that process to this guardianship process. If your durable power of attorney form does not cover certain decisions or some other problems come up, you might need to have a guardian or conservator appointed for you. A person can fight, oppose the petition. You have the right to have a lawyer help you. If you cannot afford a lawyer, the court will appoint one for you at public expense. So I mentioned adult protective services, and Jen, you might chime in on situations you folks see where a person's, again, probably living alone. Sometimes it can be a husband and wife situation where they're just no longer taking care of themselves. They're not paying bills, not grocery shopping, refusing to go see the doctor, not changing their clothes. It's usually because there's some illness or injury that's pushing them along where they're no longer capable of looking at their lives realistically and taking care of their own needs. And those people languish, and they can languish for years because the state's intervention is very limited. Adult Protective Services is very limited on doing an investigation where the outcome would be where they file a guardianship. It's very, very rare. Back in the day when I started working, it was a little bit more frequent that we could make those things happen. On the other hand, the people that are living in those states of decline, there's tons of them, right, Jen? There's tons of them. I mean, it's just not like one person in the neighborhood. Yeah. There's 7 or 8 in every street, right? So to think the state could manage that huge number of needs and keep having guardianships filed. And when you think about most of these people are impoverished, so who's going to be the guardian? A guardian means you are legally on the hook for proper decision-making for that person. So again, if you have an estate, you'll get a professional services office. Typically, it's someone in an attorney's office that's willing to work guardianships that they hire, but they're getting paid big money to do that. For someone who has nothing, it's well nigh impossible to get a guardianship filed. I don't know if you want to chime in on that.
I don't have a ton of experience with guardianships. We had one gentleman that was from Germany. It was actually a similar case. He was from Germany, he had dementia, he was 94, he lived alone, didn't have, his wife had already died, they didn't have any children. He had his wife's brother lived in Cle Elum, and kind of looked after him a little bit, but was in denial about his dementia. And we tried to get Adult Protective Services in. They came and investigated a couple of different times and basically wouldn't really do anything. And it took, unfortunately, him finally going to the hospital and the staff at the hospital filing for guardianship. So he was actually admitted at the hospital for 4 months before the state approved guardianship. And, then I think they made his brother-in-law the guardian, but he did have about 250, 300.
So he had money. There you go. It's so crazy.
So it's really, really difficult.
Yeah. So there's an example of that. The state's intervention is going to be very limited. And it's unfortunate because folks will call us at the county and say, well, my neighbor, she's not paying her bills. Nothing's happening here. And we can make a referral to Adult Protective Services as a person who's what's known as self-neglecting, like they're not taking care of their own needs. But for that to actually proceed in a direction where there's a guardianship filing, again, is very, very rare. So we try to help that person with persuasion, trying to surround them with services, maybe that don't cost them anything, like home delivered meals and things like that. But if a person's really digging in their heels, especially if they live in their own place, if they're living in an apartment, we usually can get a little leverage over them through landlords and things like that. But if they're living in their own home, they could decline for years to the point they may die in that home for not taking care of themselves. So.
And I think just to highlight the flip side of that too, right? I mean, my mother has Alzheimer's. And so early on, when I realized we were going down this road, I just became a lot more aware of different cases of people with dementia out there. And I read a story about a woman, she didn't have any kids of her own. She had a stepson through her husband. Her husband had predeceased her, and that she didn't have any documents in place, right? So there wasn't anything making her stepson her power of attorney or anything like that. And as she declined, kind of a similar situation, she ended up in the hospital. The hospital went to the state to file for guardianship, and they had a guardian, they did assign a guardian to her care. But that guardian made decisions that the stepson didn't agree with and said his stepmom would never have wanted for her life. So, it kind of helps you understand too, there's a reason why it's difficult to get a guardianship.
Yeah, absolutely.
Because you really want to make sure that people's wish, it's also another great reason why we all need to have these documents in place.
I know, it's so true.
Naming the person that we trust to make our decisions for us as that decision maker. So that, we don't end up with somebody that wouldn't make decisions for us the way we would want them done, appointed to us by a state. So
true. I mean, that is really the bottom line. It's all about that communication early when everybody's healthy and talking about what's the future going to look like and who are going to be the people I trust to be the decision makers when I get to the point where there's an illness or injury and I'm not capable of making wise decisions anymore. State of Washington, again, has pretty strong oversight over things like this because a person who is assigned a guardian does have an obligation to report to the court on what their activities are. But even so, they're not going to know that person as well as the child's going to, right? So yeah, you're going to basically bring this stranger into the situation for being decision maker. Sometimes that's a good thing. Like the gentleman I mentioned in the earlier situation, he was kind of done with his mom, but didn't want to see her do poorly. He just didn't want to be fighting out with her anymore. So once the guardianship was assigned, he was like, okay, I did what I need to do. She's got a guardian now, and I'm not going to, interfere in that. But on the other hand, yeah, it can be a situation where if they had talked and done something, then this guardianship shouldn't have happened, hopefully. So any questions on all that? Okay, next. I would say, again, state of Washington, I don't know it specifically from other states, but state of Washington is always kind of adding more rights, I guess it would say, for people in these situations. So even in the guardianship situation, they've added where, say a person's incapacitated or homebound, the person filing the petition has to arrange for that person who's in that home to somehow be involved in proceedings. And sometimes that means even they would have to do some sort of an audio link or Zoom link so that person can participate in the proceedings. So it didn't used to be that way. It used to be, well, that person's obligation is, if they're summoned, is to appear in court or have an attorney help them with the counter filing. And if you didn't, it would just go through. And now they're saying, no, we have to make sure that person is a participant in these guardianship proceedings. So again, this is where the state of Washington is pretty protective over those situations and wanting to make sure things happen. On the other hand, like I said, with power of attorney, it's kind of the Wild West. If you have that power of attorney form, there's really nobody that's monitoring you. You're not reporting to anyone. Now, you could certainly be found to be a fraudulent power of attorney or an exploitive one. But just day-to-day decision-making and things, it's really within that family that's going to decide what's happening among those people. And again, we get clients that call all the time and say, my brother's no good as the power of attorney, or my sister's no good as the executor of the will. We have no way to know what's happening there, nor would we want to, because that's a family dispute. It's a family dispute. Portable orders for life-sustaining treatment, also known as a POLST document. So if you go to the doctor nowadays for any kind of significant visit, one thing they're going to ask you, in addition to powers of attorney forms and living wills, they're going to ask you if you have a POLST document. So a POLST document, if you're seriously ill or in very poor health, physician, PA, or advanced registered nurse practitioner can use the portable orders for life-sustaining treatment to represent wishes for future care as clear and specific medical orders indicating what types of life-sustaining treatment you want or do not want in case of a medical emergency. If you have poor health from one or more chronic or serious medical conditions, talk to your doctor about this form because it's really a document that comes from a medical provider, your doctor. I don't think you can order these and bring them to the doctor. I think the doctor's office is supposed to have this discussion with you, go through it and sign it in the doctor's office. And it's all about life-sustaining treatment such as cardiopulmonary resuscitation, specific to things like emergency responders coming out, or if you're in a hospital or an intensive care unit. In my experience, this is something that typically people would want to have as similar guide to like a living will or an advanced directive. But it can also be used for frontline responders, and I'll let Jen chime in on that a little bit. For people that are already in a very unstable health condition, and then there's a 911 call, or you folks need to go out, and then maybe you can kind of fill in the gaps on there and what you look for with the POLST form.
Yeah, it's a bright green, neon green form, and it's kind of a hard stock. We generally recommend people put them on their fridge or back of the bedroom door. That's kind of where we tend to look as first responders. And there's a couple parts to it. So the first part is strictly about if your heart has stopped, and we just did this with my mom, and I actually really like the way my sister phrased it. Is if you have died, like essentially, if you have died a natural death, do you want someone to attempt to resuscitate you, right? Or do you want to just be allowed for that natural death to occur? And unfortunately, that's not often how, in fact, her primary care provider did not phrase it that way. It was like, you said, if your heart is stopped, do you want them to do CPR? And a lot of people don't necessarily understand that we're talking about if you have died, do you want us to initiate CPR, and really what that looks like, right? We're probably going to crack some ribs.
Yeah.
We are trying to reverse the course of natural death. And so that first part is just about that. Do you want attempted resuscitation? Yes or no? The next part is more about if there's something going on, right? If I'm unconscious or, I've got a systemic infection or something like that, do I want full treatment?
Yeah.
Do everything, put a tube down my throat, give me electrocardioversion to restart my heart if I'm in not a good rhythm, whatever that might be, do everything to keep me alive. Or, I just want some limited interventions, right? So maybe give me a breathing treatment, or if I've got an infection, give me some IV antibiotics, but don't go the full course, right? Or I don't want anything done. If I am in, a condition that is not compatible with life, then I just keep me comfortable, and that's it, right? So those are those three options. And then depending on which options you choose, there's some additional questions about if you want nutrition, artificial nutrition, given parentally, or, things like that, that kind of gets a little bit more in depth on. But those are important documents to, again, talk with family about. Make sure that they're posted where emergency responders can find them. And generally, it's recommended that the original accompany like portable orders. So if a patient, is transported to the hospital, generally the original is supposed to go with them. That doesn't always happen, but so that the staff at the hospital are able to follow those orders as well.
Yeah, I think again, this is an early discussion and thinking about having these documents in place, having them visible in the home. We typically say on the refrigerator they should be posted. We also have the red files of life. I didn't bring any today, but that is a little pouch that has medical information that you put back in the pouch. Has a magnetic strip to hang on the refrigerator. You can call us and we can mail those out to you if you want one. Again, this is to help the East Fierce Fire and Rescue Response Team to kind of understand illnesses, injuries, allergies, who to contact, the POLST forms along with it. So they have some guide there when they're trying to decide what the best course of response is in those situations. So yeah, this is another one that's really good to have. You're going to be asked about this at the doctor's office. If you go in for any kind of surgery or care, they're going to want to make sure this is in place as well. And again, this is a discussion you want to have early. In terms of some of the decision-making, I'll reference kind of like a burial plan thing we had in our family. People asked about that. I don't really include it in the talk, I probably should, but people often have a prepaid burial plan. So they've assigned a funeral home to handle their body, and then the disposition of your remains, whether you want to have embalming so they could have an open casket funeral or cremation, whatever the case might be. Then there's issues with how long is the body going to be stored if you are going to have it be an open casket, because you might be planning a funeral for folks coming in from other states to your funeral. Sometimes in that storage where the body's going to take weeks sometimes. So that's a separate thing that I should probably add to this, but just as an example of that communication being so important. My parents surprised me because they were lifelong Catholics that they decided to be cremated. And so the Catholic Church had kind of changed its view on that. It used to be that you couldn't do that. You had to have a full body burial. and now it's okay to do it. So I met with the priest and the pastoral counselor, and they said, yeah, it's fine. The cremains just need to be kept in a vessel, and then the vessel still needs to be buried. So we got like a child's casket for my mom and dad, both times they passed away. And then we put the vessel in the child's casket and did a burial at the cemetery. Well, my parents never told one other family member about that. Again, they told me. And so when I was asked, well, what's the plan for the funeral? I told them. And this one family member was very upset because she said, oh, you're condemning them to hell. You can't cremate them. It's against Catholic doctrine. I was like, no, actually, it's okay. I talked to the priest. So again, this is just going back to talking on communication on something as basic as that. You really have to have those communications and information known to the extent possible. You may always have someone in the family, in like in a POLST document situation, who are going to say, no, I want mom, dad, I want every available measure provided to them to keep them alive. That's basically them having a difficult situation in their own personalities of not accepting the fact that mom or dad are mortal and they are going to die. And so again, sometimes you can include those people and keep them knowledgeable. Sometimes you got to think about them as a saboteur, again, because they may talk your parents out of what your parents want to do just to keep that one child happy. So again, that's family dynamic stuff, and we can help you kind of get some information to you to kind of help through those discussions. But even in the best of circumstances, there's going to be some clashes within families. So next. So hospice care, palliative care, this is basically an end-of-life method of treatment that's become much more available than it used to be and much more used than it used to be as well. So hospice services for folks who are on Medicare, it's always covered under Medicare Part B, even if you have a Medicare Advantage plan. This kind of gets into the weeds, but a lot of people have what's known as an Advantage plan with their Medicare. It's basically a managed care organization that handles the benefit for them. So Humana is a Medicare Advantage plan. So the Medicare is managed through Humana. But in one of those quirks of the Medicare world, hospice care is still handled by original Medicare. Palliative care, on the other hand, can be handled by Part B or by Medicare Advantage. So what's the difference? Hospice care is an end-of-life medical care that provides emotional and physical support for patients with terminal illnesses. This is contingent upon a doctor having said that this person's life expectancy is 6 months or less. So the example I'll give is my mom. She was on a steady rate of decline to the point where she was unconscious. She had her eyes open, didn't really respond anymore. We asked the doctor at the facility to order a hospice evaluation. Hospice came in, checked her and said, it doesn't look like she needs any kind of an infusion of a pain medication because she's not exhibiting any elements of pain. And they said, we think she could still hear you. So that kind of helps. So we would talk to her and things. But then as she continued to decline, she would develop infections and different things like that, even though they were doing a good job of keeping her clean, but she was pretty much completely bedbound at that point. So there was a little bit of a dispute then in the facility between them wanting to treat her, hospice saying no, and hospice should be the guide there. So hospice finally said, no more treatments on her. And in fact, hospice said, we don't want to artificially hydrate her. She had already stopped eating. And having the hospice team there was really helpful because again, that one family member of mine said, oh, we can't let her just dehydrate. We can't let her starve to death. And as the hospice nurse explained, at some point in an end-of-life situation, close to the very end, you can't pump food and fluid into a body that's dying. It's just nothing's going to happen. And so sure enough, once my mom stopped eating, about a week later, she passed away comfortably. But having the hospice care in place was really helpful. Now, we have patients that go on hospice, and then 6 months later, they're better, and then they go off hospice. I think my mother-in-law was on or off hospice for 3 years. So this is much more of an art than a science in terms of diagnosing a life expectancy. Again, this is where medical world kind of fails us. They don't have an exact way to say, in 6 months, you'll be dead, right? And we know people who are given a longer life expectancy that died the next day and a shorter life expectancy that are still alive, right? Friends or family members. So again, it's more of an art than a science, but it's really a view of the doctor of saying, okay, this person looks like they're in a dying process, and how do we keep them comfortable? So when a person goes on hospice care, they go off treatment for whatever their terminal condition is. So if they are being treated for brain cancer, they don't continue treatment on hospice. The treatment ends, and then it's just keeping them comfortable through that end of life situation. Palliative care, on the other hand, focuses mainly on improving your well-being. If you have a long-term serious illness, it offers a support system to you and family to continue to have a good quality of life. Unlike hospice care, those receiving palliative care can continue to undergo curative or life-prolonging treatment. So oftentimes a person on palliative care might be someone in a difficult cancer situation where they're having to go in for regular treatments and things, and they're just trying to find a way to minimize the impact of that in terms of how painful it might be, how disruptive it can be in their lives. Palliative care is really the treatment team kind of deciding they're managing this for them without having to have a terminal diagnosis in place. Any questions on that? Maybe you can talk a little bit, Jen, about hospice care and how you guys encounter that sometimes in terms of how your response is, or.
You know, there's actually some sort of misconceptions about hospice, in that sometimes a patient will be on hospice and our crews might think that they shouldn't go to the hospital because they're on hospice, that they'll end up being revoked from hospice if we take them to the hospital. But in fact, how hospice works is if we're seeing the patient for something related to the condition that they are on hospice for, then yes, if we take them to the hospital, then they may end up, being revoked from hospice. However, if they're on hospice for cancer and they've, fallen and broken their arm, then we still probably want to take them to the hospital to have that broken arm evaluated, and maybe, just have a sling put on or a splint for the patient's comfort and treat their pain appropriately. But I would always advise our crews, at least, to make sure that hospice is involved in those decision-making processes.
Absolutely,
There generally should be a packet at the scene that has the name and phone number of the hospice nurse that's assigned to the case, or at least a 24-hour triage line, and that we should be involving hospice in those decisions.
Yeah, because generally the thought is you always call hospice services first when you're on hospice. You don't call some random doctor you've seen before. You call hospice for them to kind of give you the pathway to go. So there's a good example of that.
Yeah, and to reiterate, that hospice does require a provider's orders, right? So we've had people, tell us before, well, we think so-and-so should be on hospice, and who do we call for that? They have to go through their provider. That could be either their primary care provider, or it could be a medical team at the hospital if the patient, and I see that all the time when I'm reviewing charts where, the decision is made when they're admitted to the hospital, okay, this person's now going to be discharged on hospice. And it's the orders from the physician that's in charge of their care at the hospital that orders that hospice, and then hospice will go out and do an intake with the family.
Yeah, another misconception is people will say, well, they're going to go, my mom or dad's going to go on hospice care, and so they're going to take care of her. Well, it's not a team that takes care of her. It's like a management team. You'll have a nurse, a visiting social worker, maybe a pastoral guide of some kind, minister, but they don't bring in 24-hour caregivers either. So there's some people that believe once hospice takes over, I'm done, as family caregivers. No. We typically have lots of folks on our caregiver programs who also have hospice in there, but hospice doesn't provide the care. They provide the support.
Right.
They do.
That's a good point. It's not 24/7 care.
It's not,
and that
It is, like you said, there's a triage line you can call for guidance, but they're not there 24 hours. Okay, next. Last will and testament. So this is post care, of course. This is after the person's already passed. But one thing I always like to point out on this is that everything else we talked about goes away when the person dies. So we often have someone who call us and say, well, mom never filed a will, but I was her power of attorney. It doesn't matter. Mom's dead now. So powers of attorney, healthcare directives, POLST forms, that's all while the person's alive. Last will and testament is determining the decision-making for the estate after the person's passed away. So more commonly deferred just as a will, a legal document allowing a person called a testator, that would be me, to designate someone to receive items of my property after my death, appoint a personal representative, also known as an executor, to administer the estate. If I had minor children, who's going to take care of the children, all kinds of different things like that. Typically, a will would be one part of an estate plan. Sometimes it's usually limited on what it can do in terms of managing financial accounts, real estate, and things like that. That's why we did a family trust with us. But having the will, just like having the power of attorney documents, is something that should happen long before bad things are going to occur. It should all be part of that same discussion and setting it up, knowing where it is, knowing who the executor is. These documents, you have to know where they are. So we always recommend that the assigned family member that's the decision maker, other trusted family makers have these documents in a place where everybody knows there is, a file cabinet, whatever the case might be. If you have a family attorney, sometimes the family attorney is going to want to keep these documents as well. And the person that's assigned as the executor needs to know that they have been assigned as the executor, because it's a lot of work. It is a lot of work, believe me. Having gone through it, it's a lot of work. But lacking a will, you're going to go through what's known as the probate process. And the probate process is basically, again, you're going into court and having a judge review the estate and having that judge approve who's going to be the administrator of the estate because the will is not in place. And we have lots of clients that'll call us and say, oh, we did a will with mom or dad. We don't know where it is. What do we do? We can't go look for the will, right? We don't know where it is either. So it has to be in a visible place where everybody knows what it is so it can be used. And again, there's no last will and testament police force out there. So if you call us and say, my brother's the executor and I know mom wanted me to have her classic car and he says no, he won't show me the will, that's a family dispute. That's a family dispute. Probably going to require attorneys to get involved, summons, court appearances, the whole shebang. And we've seen a lot of these high profile situations, that one famous one with the Casey Kasem, the radio guy, and that wife that he got, supposedly she was corrupt and the children were trying to battle her for the estate. And they claimed that she was hiding assets and she claimed, no, they were no good. And so it all played out in the public eye because he was a celebrity, but those battles go on all the time. So again, the more people that know what's in there, the better. In my view, I've heard of some elder law attorneys say, no, only the executors should know what that will says. I don't think that's good practice. I think if I'm setting up a will, I need to know everyone that's named in that will should know what's in that will. And everybody should be aware of that. Otherwise, you get suspicions, acrimony, double checking, second guessing, all that stuff that goes on. So
that may be attorney specific, because when my stepmom died last year, I mean, my dad was her executor, but my two sisters and I and our four siblings all got copies of her will.
that's good practice, I think. I think that's good practice. I guess I could see it in some sort of situation where there's a fear of undue influence, like if the will said, four siblings, 25% share of each sibling. Maybe there's a fear, like if there's one sibling that might be somewhat, corrupt, that they might start whispering in mom's ear, no, I deserve more, maybe that's why they say that. I guess it could be specific to the family situation. It wasn't an issue with us. We wanted to make sure that everybody knew what the dispensation of the estate was going to be. So, all right, next. And this is just health and safety tips if you are a family caregiver, to think of always taking care of yourself. So I just added this at the end here because my expectation here is that we're all at some point probably going to be caregivers for someone in the family. I've been through it. Jen's been going through it. Other people in the room have been going through it. So I just wanted to really keep these pages in there as kind of a list of resources to think about, because it can be very challenging to you emotionally and physically to take on that caregiver role. Most of us would like to think that our parents to the end of their life are always going to be capable. And it's funny, I even have thoughts of myself. Mom lived just short of 93. My dad lived just short of 96. If they had died at 90 from a heart attack, I would tell stories very differently than the ones I tell. I would say, it was amazing. They lived to 90. Mom died of a heart attack or dad died of cancer, and they never suffered from dementia. And we had all the documents in place. But those extra couple of years, mom, terrible dementia, my dad, dementia, falling, And so then the story I tell is very different about all the work we had to do to manage things for them and all the bizarre behaviors that went on and all the family acrimony that went on. And as the caregiver, all the second guessing you do of yourself and the doubts that come in. And years later, I'm still kind of thinking through that and thinking back and saying, did I make the decision too early? Did I make the decision too late? Maybe I should have waited, But having the documents in place made that all so much easier. And my parents, thankfully, were cooperative with that process. So we had everything in place to make sure we provided them the care that they needed. So next. Stress reduction techniques, medication, prayer, yoga, taking care of your own healthcare needs, proper rest, nutrition, exercise, pleasant activities, caregiver support groups. We're fortunate right now. We've got 2 or 3 going on, and they're all in Tacoma area, but we do have some going on. I think there's some virtual ones through the Alzheimer's Association you could latch on to as well. It's nice to be able to normalize those situations with people that have gone through it. My wife went through it for close to 20 years with her mom and dad. And then shortly thereafter that, my parents started to decline. So I could really rely on her for a lot of guidance. It's really useful to have people that have also been through it that you can share things with, because we all have that question of, am I doing it right? And there's plenty of books. There's that one, what's it called? The 25-hour day. I think it's all about 36-hour day. It's all about how much you have to pack into a day as a caregiver, and it never stops. So there's good literature out there as well about it as well to kind of help you through it. So
yeah, and I'll just say personally, I attend a monthly caregiver support group for adult children caring for a parent with dementia, and we just had it last night, and it has just been unbelievable. I've been going since August, and it has been a complete game changer for me in terms of just that normalization, knowing that the things I'm experiencing with my mom, I'm not alone. Other people are going through them, and just watching the faces of other people in the group last night, some of the newer people, hearing, oh my gosh, your parent does that, so does mine. So that's, that's to be expected. And there's a couple in there. He actually is now one of the co-facilitators because he ended up having to put his mom in an adult family home. And so he shares a lot of his experience. Well, his wife now is seeing things in her mom consistent with dementia. And so they're sort of going through it all over again. But it is just remarkable how much we learn from each other. Just learned about some hydration candies last night, because it's difficult to keep older folks hydrated, and particularly when they have dementia.
Yes, yeah.
And there's these little candies called jelly somethings, and they're like 95% water.
Nice.
And so it's a great way, people with dementia, they tend to get a sweet tooth, and it's a great way to kind of throw some hydration in there when they refuse to drink water. So just learning about little things like that, it's an unbelievably supportive group. So I can't stress that enough.
That's
that
good.
When you're going through it, knowing that you're not going through it alone is huge.
Yeah, and it's fun to share stories too. Sometimes you can pull some humorous stories out of that, because I think all of us are, we raised with our parents. We had such great respect for them. We don't want to see them as objects of humor, but on the other hand, in those dementia situations, sometimes some really hilarious things happen, and it's just nice to be able to share that with people that understand, you kind of have to laugh through that pain sometimes. You have to just take a situation that's just completely out of control sometimes and say, this is how I handled it, and I did the best I could. But in hindsight, it was probably the dumb thing I did. And it's fun to be able to poke fun at ourselves and the challenges we face. And those support groups are really good for that. So supportive counseling is needed. You can certainly call our office. We'll help you with that. I did leave a caregiver, Multi-Care has a program called the Care Pairs program. It's a coaching program that's free for caregivers. I have the flyer on that on the back of the table there. And again, acknowledging feelings, understanding it's going to be frustrating. You're going to be angry, upset at times. Try to change the negative way you view situations to avoid despairing. And like Jen recommended, I did too, attending a caregiver support group in person or online. A lot of resources here on this last page. Our office number, I didn't talk a lot about facility care, but the Pierce County Long-Term Care Ombudsman for Pierce County is a professional employee for the county with a team of volunteers, and their job is to really determine quality of care and do dispute resolution, mediation, for folks who are living in care facilities, whether it's an adult family home, a nursing home, and assisted living facility. So they also can help guide you on looking at different facilities, what they provide in terms of Medicaid funding or private pay, memory care. So they're a wonderful resource if you're looking at care facility situations for a family member in Pierce County. Washington Law Help has the forms, if you need them, the power of attorney forms, the living will forms, those are legal in the state of Washington. So if you just wanted to go on there and print those out, you could do that and get a notary. It has an explanatory page as well. You don't necessarily have to engage an attorney to get those documents in place. We recommend that you do, but you don't have to. If you wanted to engage an attorney, you could talk to the Tacoma Pierce County Bar Association. They have a senior citizens wills and trust panel, I think, where they'll set up the power of attorney forms, the end of living will, and the last will and testament for a reduced fee. So that's another way you can go. Information on 5 wishes, Medicare, the dementia legal planning project. This is another option. I have the flyer in the back. That's a legal service the state is sponsoring to set up power of attorney forms and living wills for anyone with a dementia diagnosis or who's 60 years of age and older. So there's a lot of resources out there right now that you can use to set up the documents we talked about and get some guidance on what's the best way to go. So, and that concludes the presentation. So any questions, comments? Otherwise, grab some resources in the back there. Always feel free to give us a call at our phone number. Take some extras if you have a friend or family member. Plus, I think we recorded it, right? So
We did. I'm gonna end the